And thank you for joining us here on PM Express. It's a big day for our constitution, democracy, the balance of power in Parliament. This verdict has serious consequences indeed, and we're going to be getting into that. We're going to look at the big picture because the question is what now? The ruling has calmed down, but what now? Very fascinating outcomes that a lot of people are predicting, and we're going to get to the bottom of this. Let's start because there's a lot to get through for you. We know, if you're just joining primetime television at 9 p.m. and you haven't heard, you probably just returned from work, the Supreme Court today has ruled that this man here, he's a member of Parliament for Assin North. He can no longer go to Parliament. He can no longer perform the duties of Parliament. And until the substantive case before the Supreme Court is heard. So what means in effect is that the NDC will no longer have a seat in Parliament, but this is an interlocutory injunction. So this is going to be so until a matter is determined. Nobody knows how long it's going to be, except if you read, and I've been reading the Supreme Court judgment that thankfully is out. And you must applaud the Supreme Court for being really timely in releasing the judgment so we can all read and be informed and end the speculation debate. They have indicated that they want the substantive matter determined expeditiously. And so they've already asked the parties to file additional processes later this month. And so that is the case. But what it is James Achikwesi cannot hold himself out as a member of Parliament. The Assin North constituents will no longer have him on the floor on their behalf. That is the fundamental consequence of this. Now, how did the court rule? The court ruled 5-2. So there were 7 justices in all, and 5 of them ruled that he should be injuncted. He should be stopped from performing his duties as a member of Parliament for now, until the case is determined. 2 of them disagreed that, he can continue with the status quo, which is what indeed was happening. He was going to court. He was going to Parliament. There's been challenges on this. So that is the decision of the court, and this is interesting. So this one unanimous. It's 5-2 of a majority decision. I talked about the status quo. That was also a subject of some debate in the ruling of the court and explaining it. The 5 who said he cannot hold himself, they talked about the status quo. They said the status quo is what the High Court has decided. The High Court decision is that he did not qualify to be a member of Parliament in the first place, and he was injuncted, but as you know, on the 6th into the 7th of January 2021, he was in Parliament causing a lot of controversy. So there's a lot of intrigue there. So who are these judges who came to this conclusion? The majority decision, these were the individuals who, of course, came to that conclusion that he cannot carry himself out as a member of Parliament. Then Justice Doche, Justice Mariama Owusu, Justice Gertrude Tokono, Justice Professor Henrietta Mensah Bonsu, and Emmanuel Yonukulendi, who had written that opinion. And the dissenting judges, Justice Agnes Doje and Justice Nanya Megache, came to the conclusion, very fascinating positions taken by both. I want to go through that a bit for you right now. These 5 said this in essence, that the court ruled that the case filed raises serious allegations of constitutional breach. In fact, they placed a lot of weight on this constitutional breach in coming to the conclusion that there's a reason to injunct. There's a reason to stop him for now because the constitutional breach for them is a key. In fact, the phrase used is that we all have an interest in the Constitution, right? And so this matter affects not only James Achikwesi, all the applicants, all the constituents, all Parliament. It affects everybody else. We have a community of interest, I think is the phrase, a community of interest in the Constitution. So that was key. And then the sovereignty of Ghanaians be breached if the MP is not restrained. They also said such a breach is incalculable and cannot be remedied. That's a very interesting point indeed. And that if he's not injuncted, as it is right now, the argument is that the harm this will be done. You can't calculate it because you're talking about the supreme law of the land. The reverse, when it comes to the 2 dissenting opinion, that's so very, very interesting. Their point is fundamental, that this case was already decided by the High Court, right? And so they make the point that the case that has been brought to the Supreme Court is academic, simply academic, because the High Court has already decided and given the applicant in this case all the reliefs he seeks already. He already has everything. So what's the point in coming to the Supreme Court? In fact, they concluded that this is frivolous. This is not something that they should waste their time on, and it is an academic. And if you read the reasons why they will injunct a matter, I mean, the principles that governs an injunction, one of them is to determine whether the case itself is frivolous or not. Those dissenting said it's frivolous because the matter has already been decided by the High Court. If decided by the High Court, why do you come here with this? And then the second thing, who is going to suffer the greater damage, right? They come to the conclusion that the applicant in this case suffers no damage at all. Why? Because the High Court has given him everything he wants already. If you really, really intend on benefiting and enjoying the orders of the court, you should simply go back to the High Court and get an injunction. That is, if James Achikwesen is not obeying the orders of the court and violating the Constitution, go back to the High Court and get reliefs there. So he doesn't suffer any damage at all. And so they threw it out. Those are the two views expressed there. We'll get into the key issues here. But there are timelines, and if you haven't followed this, you know what happens. James Achikwesen wins the polls in the elections in 2020. Then Michael Ankoma Nimfa, he petitions the High Court first. He alleges when he petitioned that Mr. Kwesing was a dual citizen, was holding a Canadian citizenship, whilst he was also a Ghanaian, and was here trying to run as a member of parliament. The Constitution expressly forbids that from happening. You cannot hold a true citizenship, two passports and run, right? So that was his case in 2020. Now, January 2021, fast forward, the High Court then restrained Mr. Kwesing from holding himself out as a member of parliament. July 2021, the High Court nullified the Assin polls and calls for fresh elections. They ruled, fundamentally on behalf of Mr. Nimfa. And it says the MP then appealed at the High Court after this. He didn't stop. He goes to the appeals court on the back of this. Then January 2022, Michael Nimfa files a case at the Supreme Court. What does he want? He wants the court to stop Mr. Kwesing from performing parliamentary duties. He takes the substantive case, in essence, back to the Supreme Court, wants an interpretation that he did not qualify. The Supreme Court should interpret 94(2)(a), which says that if you are a dual citizen, you cannot run for public office in Ghana. But that's the case that has been determined by the High Court. So we'll get some clarity on this. Then March 2022, Court of Appeal strikes out the appeal filed by James Achikwesen. So along the way, James Achikwesen keeps losing, right? That's why the Supreme Court, those who descended said, but you have everything already, so why are you here? And in April 2022, Supreme Court now restrained the Achikwesen from carrying himself out. That's why we're having this conversation. Now, the reactions have poured in. The minority in parliament is considering a review. Constituents split on this verdict, but there are many fundamental issues that we need to interrogate. So what happens now? Okay, so he can't hold himself. So what happens to the constituents who require representation on the floor of parliament? So is it 274 and not 275? And what does that mean for the voting quorum question that the Supreme Court recently decided? I mean, so there are really fundamental issues. And how long do the people of Assin North have to wait until they get a replacement? Can the EC go ahead and call a by-election and organize one? Should Parliament simply, through the clerk, reform the Electoral Commission that there's a vacancy? There are real matters still need to be decided. And I want to get some clarity for you if you stay with me after this break. My guest joining me right now, Alfred Yeboah. He is the Deputy Attorney General, and he's my guest on Zoom. Thank you very much, Mr. Yeboah, for your time here on PM Express.
You're welcome, my brother.
Also joining me is Professor Stephen Kweku-Asare, CDD Fellow in Public Law and Justice. I'm delighted because he has strong views not only about this particular case, but also about this dual citizenship matter. I've seen and read a lot of the things he's writing about it. So there are many more aspects of this that we'll explore, and I'm happy that he can join us. In the studio with me is Godwin Eduji Tamaklo, member NDC legal team, and joins me in the studio. Let me start with you, Eduji, because you're in the studio with me. So the verdict is here. In effect, and explain this to me if you agree, that he would henceforth not go to Parliament.
Yes, so Evans, once again, good evening and good evening to
Forgive me, we need to fix your audio, and so we'll get that fixed sort of quickly. But let me go to, whilst we do that, let me go to the Deputy Attorney General. I mean, so, Mr. Chayibwa, so this verdict has been delivered. I noticed that you were actually a defendant in the matter. Sorry, I can't hear you.
Yes. So as someone would say, we're sitting somewhere there, somebody decided to sue us. So as usual, we had to defend. So we're the third defendants in that suit.
Okay. So you went before the court. Did you attempt a defense, or you agreed with the position of the applicant? Well, give me a sense of what your position has been on this matter.
Yes, we went to court to state our position on the matter as a defendant in the suit. And our position, coincidentally, is the same as that of the plaintiff in the suit.
Okay.
So even though a third defendant, we have our opinion just like the views held by the plaintiff.
So you believed he could not hold himself out as a member of Parliament because of the High Court's decision earlier that barred him from doing so. That's your position?
Our position has been that there is a subsisting High Court judgment from Cape Coast. Mm-hmm. That High Court judgment was appealed against. When they filed the appeal, they filed a motion for stay of execution. Because there was a stay of execution, there was no way he could restrain from going to Parliament until and unless that application was determined. And we were of the humble view that insofar as there was a substantive judgment and he continued to be in Parliament, he was breaching a constitutional provision.
So this judgment you referred to again is the High Court's judgment?
The High Court's judgment.
Okay.
And this appeal that they filed was struck out for want of prosecution, for non-compliance. And that appeal that was struck out together with other cases like the motion for stay of execution. So technically and legally, there was nothing holding any other institution from either restraining him or compelling him to do an activity.
Okay.
And for that matter, we were of the view that Supreme Court was seized with the jurisdiction to determine whether to grant the application or not to grant it. But insofar as Supreme Court had the jurisdiction to entertain an application, we were of the view that that application ought to be granted, and it was granted.
So let me put it to you, the dissenting judges, let's go to the substance of this, and I'll bring in Eduji and Prof now. So to you on this, as it is now, the Assin North constituents will not have a representation in Parliament. Now, the dissenting judges talk about the fact that we're talking about the damage that would occasion the people, in case a substantive matter, which, by the way, still borders around whether he's qualified to be a member of Parliament or not, the Supreme Court will still hear. If what has happened today, if the Supreme Court declares that he was qualified, for example, which is a probable outcome, you've really done irreparable damage to these people of Assin North, who you can't compensate with money, for example. Is it prudent to rather keep him there until that matter is determined.
Yes, Evans. What about the other way around? If he loses the substantive matter, and he has taken certain decisions or certain steps that he ought not to have taken, can the people of Assin also compensate us? That the people of Ghana, that would be a blight on the Constitution. Can they also compensate the people of Ghana for allowing someone who ought not to have taken part in the decision process in Parliament?
The dissenting judges had an answer to this question. Their answer is that you have recourse to the High Court to enforce its judgment by taking a contempt charge against him.
It is true that the plaintiff in that case has the right to proceed against Mr. Kwesen for flouting an order of the High Court. But that does not in any way also stop such a plaintiff from pursuing a writ at the Supreme Court, which is a different matter, and also asking for an injunction to be granted. So far as we are concerned, the plaintiff had the right to be in the Supreme Court by initiating a process and also asking the Supreme Court to grant an application in respect of an injunction.
I mean, Eduji, 5 of the justices agrees with this position. In fact, they make the point that the possibility of a constitutional breach, which all of us, and they make the point, have a community of interest in, outweighs all other considerations. And so if it turns out that indeed he is not qualified, the damage to the Constitution, to me and you and everybody else, it's incalculable. And that's why they decided that injunct him while the case is being heard.
Ivan, so once again, good evening to your viewers. I think what is clear per this ruling of the Supreme Court is that we are basically changing the rules depending on what the circumstances are. And listening to the Deputy Attorney General, the Honorable Deputy Attorney General, I am filled with a lot of regrets in the sense that our Deputy Attorney General makes the point that when you obtain a judgment in the High Court and someone decides to be in contempt of that decision of the High Court, your resort is to issue a writ at the Supreme Court to restrain that person from that contemptuous conduct.
But it's a substantive matter.
No, but listen, if you read the ruling, obviously by the majority, authored by His Lordship Justice Kulendi, you will notice that the decision is predicated not on the substantive rates, but the matter that is before or had been decided by July 2021. And that is why if you look at the dissenting opinion, Her Ladyship, Agnes Doji GSC, makes the point that it appears what has happened is an academic exercise because it is just unheard of that a High Court gives you judgment. And as recounted by the learned Deputy Attorney General, there was no subsisting appeal, there was no stay of execution. So what it means is that you have a judgment. Now, if you have a High Court judgment, do you go to the Supreme Court to have it enforced? No. And I want to believe that, even in his practice, many years practice as a lawyer, he had never approached the Supreme Court to enforce a High Court judgment for him.
But let's clarify.
No, two.
That's not why they went to the Supreme Court.
No,
they went to the Supreme Court for a substantive interpretation of Article 94.
But I'm
2A.
saying that.
And it's in that cause that they said, okay, whilst you determine this injunct.
No. The Supreme Court today, and if you read the majority decision, His Lordship Justice Kulendi does not proceed on the basis of the alleged constitutional breaches, but takes the view that the plaintiff is alleging that the continuous stay of the MP having a judgment obtained against him is contemptuous. and that should not be permitted. And that is why if you look at what my Lord Justice Nene Amegache stated, he said, look, this level of legal ingenuity should not be permitted. You do not clothe an enforcement of a high court decision or judgment as though it's a constitutional interpretation matter. Beyond describing it as disingenuous, he calls it legal ingenuity. Because on the face of it and the majority judgment, it was clear that they were not seeking to enforce Article 94 2A. Because in any case, it has not been interpreted. What they said in their judgment, the majority ruling, is that there was a judgment obtained against the MP.
But let me read something to you.
Yes.
This is just the majority.
Yes.
We are clear in our minds that this application is founded on a writ invoking original jurisdiction, does not arise directly from the prior actions in the High Court. Consequently, neither original jurisdiction nor the application are granted on the High Court. However, in the exercise of our discretion, the antecedents in the High Court are relevant facts that will inform our evaluation of the equity, justness, and convenience of a grant.
So go to the analysis.
But they are clear. It is not directly.
Go to the analysis of why he was injuncted. Has nothing to do whatsoever. Because you see, like I pointed out, the Supreme Court is the forum for dealing with presidential election. Correct?
True.
Have you ever seen in any presidential election where allegations of constitutional breaches, violations of our electoral laws are made, that the president is injuncted? Have you seen that before?
No.
We've had 2 presidential election petitions in this country. Have you seen that the mere filing of a petition against a president, that he has been injuncted from performing that function?
What's the point? Because this is not the same. This is
No, but it's election petition. It's electoral dispute. It's electoral dispute. There is sound policy reason why you don't injunct the president. In fact, for constitutional office holders, they are barely injuncted. Because in doing the evaluation of the Balancing Act, you look, this is a plaintiff, Nympha. This is, the MP. Now you have created a constitutional, quote-unquote, crisis. Until this rate is determined, the people of Assin North are left without representation. How do you feel the lacuna?
The judges actually they are mindful of this. Is the reason why they say they will expedite the determination of the substantive matter.
Please. And that is why His Lordship Justice Nene Amegache provides a solution.
Which is what?
He said, when you have such a matter, because a determination of the injunction may prejudice the eventual determination of the substantive matter, what you do is to consolidate and give a substantive ruling that determines the right of the parties at once.
Okay. Stay with me. Let me bring Professor. Professor, sorry, so where do you stand on this?
Well, thank you so much for having me. Where I stand on this is there's a lot of procedural confusion in the judgment. Because remember why there is this injunction. There is this injunction because the plaintiff has issued a writ at the Supreme Court asking for the interpretation of Article 94 2A. The plaintiff is saying he doesn't understand Article 94 2A, and so the Supreme Court should help him understand that.
By the way, therefore, mere mortals, just for mere mortals, 94 2A simply says you can't be a member of parliament if you are a dual citizen.
No,
Sorry.
if you owe allegiance.
If you owe allegiance to another country,
It doesn't just say that. If it just said that and it was understood, the plaintiff will not be in court. The plaintiff issued a writ. And if you want, read the release that the plaintiff is seeking in that writ. Justice Doji, as well as Justice Amegache, recite the release that the plaintiff is seeking. The plaintiff is saying, I don't understand Article 94(2)(a). So court, help me understand it. But there's a judge somewhere in Cape Coast who has interpreted Article 94(2)(a) and told the plaintiff, hey, plaintiff, I'm going to grant you all your reliefs. And the Supreme Court is sitting there saying, well, yes, we don't understand Article 94(2)(a), and we are going to interpret it. But meanwhile, we think it is okay for some high court judge not only to interpret it, but to issue and grant injunctions, setting aside the wishes of voters when there is a law that, look, voters' decisions must be treated with the highest level of deference, and they are not to be set aside willy-nilly. In fact, to cancel an election in our jurisdiction, one must show that at the time of the election, not at the time of the primary, not at the time of the nomination, not any time, at the time of the election, the person was not qualified. So regardless of what the Supreme Court will tell us 1 week or whenever they want to tell us, there's just no ground for the High Court judge to have determined that, one, he's going to interpret Article 94(2)(a), two, he's going to put his own timelines in Article 94(2)(a), three, he's going to injunct the MP. And remember, he even injuncted the MP on 6th January. He didn't want the MP to sit in Parliament even before Parliament convened, even before hearing the matter. Now, yes, one thing that people should take into account. At the trial court, the High Court in Cape Coast, there was really no trial. There was no trial. The High Court simply took the arguments of the two parties, went to Wikipedia and copied some phrases from Wikipedia, and based on that, ruled that the MP owed allegiance to Canada. And mind you, you have been referring to dual citizenship, but Article 94(2)(a) does not say anything about dual citizenship. It says something about you owe allegiance to a country other than Ghana. Now, I have it on authority, and it is public record, that the MP had applied to renounce his Canadian citizenship as far back as November 2019. 1 year ahead of our election. Now, in Canada, when you apply to renounce your citizenship, you are required to surrender your passport and you are required to leave the country. So he applied, submitted his passport and his certificate of naturalization, left Canada, and came to Ghana to run his life in Ghana as a Ghanaian. 1 year after, he files for nomination. That nomination is challenged. The Electoral Commission looks into the matter and decides the challenger does not indeed have any grounds for alleging that he owes allegiance to a country other than Ghana. In my mind, allegiance to a country other than Ghana does not mean citizenship, because at the time the 1992 Constitution was promulgated, dual citizenship even was not allowed. So it is strange that the Constitution would say something that is not allowed, dual citizenship, is not allowed. But if you are a dual citizen, you cannot hold office as an MP. That makes no sense, because we know dual citizenship was not allowed. Dual citizenship was allowed only when we fought. And in 1996, the Constitution was amended and the current Article 8.1 was inserted to allow for dual citizenship. And what the High Court judge is doing is retroactively saying that this clause that was there for whatever reason is going to apply it to a person who has the citizenship of another country, except in this case, the MP had subjectively renounced the citizenship of Canada. You cannot say that a person who owes allegiance to a country other than Ghana, the allegiance is subjective. I owe it, and I am the one who can renounce it. And the way I can renounce it is to apply to Canada. Now, Canada may even say, look, renunciation of Canadian citizenship is not possible. If that is the case, Canada cannot perpetually restrain me from running for an MP in my own country, the country of my birth, merely because of some law that they have about renunciation of their own citizenship. So my point is, it is clear in my mind that at the time that he filed for his nomination, maybe even earlier, he had renounced whatever allegiance he owed to Canada. Now, let us also look at some precedents, because it's important in light of what the National Security Advisor was saying the other time, that somehow people who sit back and try to understand what the court is doing may get confused. There was a time when a case arose in the US about my good friend Kennedy Ajapon. He was suing someone in the US for defamation, and I looked at the rate and I quickly predicted that he was not going to prevail because I knew the US law and I was able to make that prediction. Now, if you look at this injunction and you try to predict it, you look at Ghana's law, you look at the case of Nimakan in Wulensi. He was an MP whose qualification was challenged on grounds of residence. No injunction was granted. You look at the case of Amu.
Was there an application that was turned down? Was there an injunction?
Yes. In all these cases, there's always an application.
Okay.
And any court will say, no, I'm not going to grant an injunction because the balance of harm is against the constituents. Nobody is going to be harmed because an MP who has already served 1 year is allowed to serve 2
Prof,
years.
what about the majority decision that the balance of harm is against the Constitution?
I mean, how?
That's just writing. You can write anything that you want. You have to look at the analysis. Really, why is the balance of the harm against the people who elected him? The people elected him. The people elected him at the time of his election. They were aware that his citizenship had been challenged and the electoral commissioner had ruled in his favor. So how do you then tell me, other than, you can say whatever you want in a court opinion. It doesn't mean what you are saying can meet the test of scrutiny or the test of logic. And that's what I'm telling you, that in all these cases, in the Nimakan case, in the Amu case, even in the Adamu Sankede case, the injunction was not granted. And in the Adamu Sankede case, in fact, Justice Kulendi was the one representing Adamu Sankede.
Yes.
And then he and others like Magas and what's his name? He's now, may he rest in peace, Malon. We were aggressively fighting for Adamu. And some of these issues may have come up, but the Adamu case can be distinguished from this one because this one is such an easy case. You have a situation where a Ghanaian who is a citizen of another country has applied to renounce his citizenship in November 2020. Why are we even arguing?
Yeah, I mean,
his qualification.
Stay with me, Prof. Let me get Chinyubue's take on the precedent you just mentioned there and the balance of damage that the people of Assin North will suffer in the interim. How do you respond to the points that Prof makes, Mr. Chinyubue?
Yes, some of the points I'm constrained in my response because the matter is in court and the AG is a party in that particular suit, especially as to when Article 94(2)(a) kicks in. So I might not want to veer into that. But when it comes to injunctions, it's an equitable remedy. It is at the discretion of a judge. Before a judge grants or refuses an application for injunction, he looks at all the circumstances. I think if you read the ruling, you will see a situation where they've analyzed the circumstance that which an injunction application will be refused or will be granted. A careful reading of the ruling shows that the majority evaluated the affidavit evidence, looked at the equities in the matter, and came to a conclusion that in the circumstance they found themselves, it will be equitable, it will be fair, it will be reasonable to injunct Mr. Kwesen until the final determination of the writ before them at the Supreme Court. Prof had made mention of Imakan case and all those cases. I'm not sure whether in those cases they applied for injunctions. In any case, even if they applied for injunctions in those cases, but the applications were refused, that should not constitute a bar on another court from considering the evidence that the court may have to grant an application. My learned friend Gordon made a point about the precedent election petition and that the president cannot be injuncted. It's a fact that in 2012, nobody filed an application to injunct the president from being sworn in or from performing constitutional duty. In 2020, such an application was not filed. But that does not mean that a party may not want to may not have the right to file an application even in presidential election petitions. As to whether such an application will be granted or refused will depend on the equities in that case. In this Assin North case, if you look at the balance of convenience or hardship, it is my respectful view that the Constitution, which is a ground norm, which is the base of all the laws, we must make every effort to ensure that it is preserved and protected. And that we should not sit down for people to breach provisions thereof. In that case, the Supreme Court, in its wisdom, per the majority of 5-2, came to the right conclusion that we cannot allow a running unconstitutionality to be peddling anything in our street or going to parliament if the person is not qualified. In any event, this application is not a perpetual one, it's an interim application. If at the end of the day, the Supreme Court comes to a conclusion that the plaintiff's case is not fit and proper, the status quo reverses. In that case, we go back to where Mr. Kwesen was. He goes back to Parliament and perform his duties.
So what happens to all the time when decisions will have to be taken that the people of Assin North will not have a representation of voice? How do you compensate them for that?
Fortunately, in this case, the Supreme Court made it clear that having restrained Honorable Kwesen, they have set timelines within which the parties were to comply so that the matter could be heard. In this particular case, we're not going to take evidence. It is about legal submissions. As we speak, the parties have filed their legal submissions, or what we call the statement of case. The parties have been given a day to file memorandum of issues. It means that this matter will be determined within the shortest possible time.
So that begs the question. I mean, the Supreme Court making that point, isn't that an admission that the representation of the people is so supreme that they need to expedite this? If they're going to expedite it, why not simply just wait and expedite, finish it quickly, and then you substantially decide the matter, and then we all move on, and you will not have a gap where the people will not have representation, because they're going to do it quickly anyway. Well, what's the haste?
That is the other side of the coin, that you may say he should be permitted to take part in parliamentary proceedings. But I spoke about the Constitution. We must uphold the Constitution. If there is a valid judgment of a high court stating that you were not qualified at the time that you filed nomination, and that judgment has not been set aside, you overlook that judgment and say, go back to Parliament and then perform your duties as an MP. That will be condoning constitutional preaches.
Yeah, I mean, Eduji, that point he makes, even the dissenting judges were clear. In fact, in Justice Doji, I think, what is the proper pronunciation?
Agnes Doji.
Doji's point. She says the reason why she's dismissing this application for injunction is that the applicant has all the reliefs already granted him at the High Court. He already has it. He should simply just go and get. Isn't that an admission that your client, no, not your client, but Justice Jachikwe has carried himself out in a way that breaches the Constitution, violates the authority of the court, because the courts have already decided that he cannot hold himself, and he still does so, and he has really brought him this upon himself. That's why the majority were clear that it's the superior law of the land, the Constitution, that is now at stake, because the man has shown, he referenced that he won't respect the orders of the High Court. Isn't that what the problem is?
You see, principally, and let me read this portion in answer to yours. As the highest court of the land, it will be an indictment of the administration of justice if this court did not uphold the subsisting judgment pending a final decision on the constitutionality question raised before us. So obviously, what the Supreme Court purported in this majority decision is to basically enforce a subsisting judgment. And my point is this: the Supreme Court has never, in exercising its interpretative jurisdiction, proceeded to now uphold judgments delivered by courts below. It has never happened. In these over 30 years when it was constituted under the 1992 Constitution. And I stand to be informed of a day that our Supreme Court enforced a judgment of a High Court. It has never happened. This is novel. But you see, the point being urged on us is that, you know what? The High Court had given a decision. If you read the dissenting opinion of Her Ladyship, Agnes Doji, she makes the point that if you pick the relief being sought by the writs and that of the High Court, they are almost the same in terms of the prayers. Now, if they are almost the same, then your forum or the procedure, if you think someone is disobeying a court order, and like the High Court, it has the power to commit to itself contempt. And so if you have reason to believe that Jachikwe was disobeying lawful orders of a superior court, what you do is to go back to that court with a contempt application against him or enforce that judgment against him. You don't run to the Supreme Court that I am more or less handicapped. Help to enforce the judgment that I have obtained at the court below. I have never seen this.
Let me ask you the what next question. The Attorney General today for the court told journalists that the what next question leads to one conclusion, which is at this point, nothing stops the Clerk of Parliament from informing the Electoral Commission that there's a vacancy and the Electoral Commission proceeding to hold a by-election. Do you agree?
You see, I want to quote one of the laws of this country, and that is the Representation of the People's Law, PNDC Law 284. Professor Kweku Asari makes the point that if you look at sections 21D of PNDC Law 284, it provides that an election, the election of a candidate can be cancelled if D, that the candidate was at the time of his election a person not qualified or a person disqualified for election.
Election of filing.
Exactly. He said the time of his election. In the case of Jachikwe, you will notice that the certificate of renunciation is dated 26 November 2020. When did we have our election? December 2020, correct? So if you want to reckon the time, you don't go back and say the nomination period. Because the representation of the people's law had not been declared as unconstitutional.
But
you see, hold
the
on.
Zenato case.
Good.
When the Zenato case, the court
Incidentally, I argued Zenato before the Supreme Court.
Yeah.
In Zenato, the Supreme Court never discussed the scope of Section 21D. What happened in Zenato had to do with voter registration. Article 94 2A had never been interpreted. So you need to read 94 2A together with Section 20 of PNDC Law 284. And that is where the timeline, and that is the only law that provides timeline when you can question whether a person is qualified or disqualified for an election. That was not decided in Zenato. And that is why, in all of this, we have always prayed for caution, that the matters are more weightier. And don't look at it ad hominem, Jechikwesen as a person. No. Look at it and have all the matters in controversy. I have listened to the Attorney General, and I felt very sad.
Why?
Because you see, the Attorney General proceeds on the basis of this injunction order to say that, okay, you know, what happened to Sakandi, the same fate will befall him. So it looks like the whole ruling was a revenge ruling. Look at the parties involved. It was like a revenge ruling.
Explain.
The lawyer for Sakandi was my Lord Justice Kulendi. Correct. Look, let's take certain things very serious. Because in the Sakande matter, if you recall, even when Sakande became MP, as at February 2009, the letter written to the consular section of the British High Commission confirmed that even as at 2009, he was still holding on to his British passport.
The second is an NDC.
No, MPP.
MPP.
You are the MPP MP for Boku Central, the late Adamu Sakandi. In the case of Jechikwesen, by November, before the election, he had a certificate of renunciation. How do you compare the two, if not for mischief?
Okay, I mean, so, but it just happens. So, but that then defeats the point, right? Because if Justice Kuleni was his lawyer,
no, the point I'm making is that
he can't be part of the equation.
No, the point I am making is that this conversation is not something that is new to the parties involved.
Okay,
that's the point I'm making.
Back to the point about what next. Do you support the point that the EC can go ahead and conduct the by-election there?
As you are aware, there's even a subsisting application before the Court of Appeal in Cape Coast.
Yeah.
Those matters are yet to be determined.
And then there's a Supreme Court one too.
There is a Supreme Court matter. So what will be the basis, as indicated by the Attorney General, to proceed with the by-election?
When the Supreme Court himself said we'll expedite it so that it determine final.
I mean, unless, of course, our Attorney General already knows the outcome. And that would be dangerous. And that is why if you read the dissenting opinion of His Lordship Justice Nene Amegache, he makes the point that it is for this reason, that is why you don't grant an injunction in this kind of situation, because of the tendency to prejudge the outcome of the substantive matter.
You think this one prejudges the
Exactly.
Okay.
Because you see, the reason why I make this point is that now that the MP is basically at home, the people are without representation. Then after 2-3 maybe months, you now come and say you are qualified. Go and continue that office. Have you seen what would have turned this whole country into?
Professor, sorry, just a few minutes to wrap up, but let me ask what next question for you. The injunction is here. What next for you? Attorney General has a view on this. He disagrees. What for you is the key? What next?
Well, there are so many hanging issues. Like Edugi was saying, there is a case on appeal. There is this Supreme Court ruling, which it's going to expedite. There's an application for a review of a 3-2 decision by the Supreme Court in which Justice Puamang and Justice Doji dissented. There are so many hanging issues. This, whatever it is, injunction came from nowhere. I'm afraid the Supreme Court is rushing too much into too many political cases. And I'm afraid when it does so, it's setting aside too many precedents. And I'm really worried that the Supreme Court is going to create a situation when people are not going to take it very seriously. I'm worried. I wrote about this many months ago when Samson invited me to give a New Year statement. I said the most difficult situation facing the country now is a court that is increasingly being perceived as partisan in a country where we are excessively partisan. The court must look at this case more carefully. Here you are, there's a high court judgment that can easily be enforced. Why does the court feel the need to be the one to enforce a high court judgment? It strikes me as odd. It's inconsistent with anything that you learn in law school or you figure out during your law practice. I'm really worried. I think eventually, they can say what they want, but I think eventually, once they've granted this injunction, I'm 100% confident that they are going to say, well, the elections should be held. So if I were the MP, I would resign and I'll go and run again for elections and try and win. And winning again will show us how wrong we do things and how inconsistent and how incoherent our jurisprudence has become. Okay. There's really no reason for what we are doing right now.
I mean, trying about final words to you, can that happen? Can he rerun with considering what has been determined by the High Court? And going forward, what for you is the big next step?
Yes, I want Prof. and my learned friend to look at Article 129 plus 4. A careful read of that article will tell you that when the Supreme Court sits on a matter, it assumes the jurisdiction of any other court. That's still that matter. That's the first point. Then if you take the Canadian Citizens Act 1985, Section 9, it says that until your application has been granted and a certificate issued, you continue to be a citizen. But that's Prof said, it's different from allegiance. But I'm talking about citizenship. Until you are granted that certificate, you continue to be a citizen. Whether that one is equivalent to who own allegiance is another matter. Then moving forward, the AG made it clear. It's not as if the AG said because of the injunctions, by-elections could be held. The fact is that the substantive appeal in the substantive case has been struck out.
No, but they are filed.
My brother knows that they have filed a motion to restore the appeal.
Exactly.
They filed a motion to restore the appeal, but that does not stay execution of that judgment. Now there's no pending stay of execution. So every person will be right to say, in the absence of any process stopping execution, the Clerk of Parliament will have the right to notify the EC for a by-election to be held.
Thank you, gentlemen.
Just 30 seconds. You write and you asked an important question. What next? Remember that the High Court decision that the Supreme Court depended on. In that judgment, the court made it clear that if the certificate of renunciation had come before nominations opened, he would have been deemed qualified, even per the High Court judgment. So what it means today, that if the Electoral Commission, for whatever it's worth, even opens nomination today, he is deemed qualified. So it's basically a cost 90 exercise.
Enjoy the rest of your evening, people.